Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk a bit about prosecutorial discretion. It's fairly much the only part of the big memo that came out by the Secretary of the Homeland Security and the part of immigration reform that President Obama tried to do that essentially is both untouched uh, uh, okay. Uh, Generally speaking, when I prepare a packet for prosecutorial discretion, there's all kinds of there's some general belief that they usually could for ask for one on a general basis that an NTA not be issued the notice into it basically what it says it is whatever officer has the discretion levels here is because there are people who do not fall under priority one, priority two, or priority three they're under none of the priorities. Now, this does not mean, and I found a lot of people think this, that if you're not under a priority, you're absolutely safe. You will not be deported. There's no way anything can happen that will get you deported, and that's not true. You may not be under a priority, but still, the prosecutorial discretion is 100% discretionary, meaning that if they feel the need to start deportation or removal proceedings against you, then they'll do what they have to do. So there is the no priority category also. Now, what are the three priorities? So first, you have to understand that there are certain categories that fall under these priorities, but then, which I'll get into in a few minutes, if you're under one of these categories, there are exemptions to the priorities and ways essentially of requesting that even though you might be under such a priority, that because of the various reasons and the arguments that you're submitting, that you not be placed in removal proceedings and again be given deferred action and work authorization. So priority one are those that they consider to be threats to national security, border security, and public safety. Okay, basically, they define that as persons who are engaged in terrorism or espionage, persons who are apprehended at the border while attempting to enter unlawfully, persons who are at least 16 years of age, who participated in an organized gang, and any person who has been convicted of an offense of which an element was active participation in a criminal gang, and also persons who have been convicted of an aggravated felony under the Immigration and Nationality Act. So while that does seem to enclose or encapsulate quite a few groups of people, at least you know if you are under that, you are in priority one. Now, priority two focuses more on misdemeanors that people may have committed and new immigration violators. So essentially, to fall under priority two, you have to have been convicted of three or more misdemeanors arising out of separate incidents, of which none of them are minor traffic violations, and which they are not incident to immigration violations. Also included in this group are persons who unlawfully entered or re-entered the U.S. and have not been continuously present in the U.S. since January 1st, 2014. So as it stands now, that's basically just new people coming in. But as time goes on and this memo gets older, more and more people will fall under that category. There's also another category under this priority, and those are persons who are convicted of a significant misdemeanor. Now, a significant misdemeanor is defined as an offense of domestic violence, sexual abuse, burglary, unlawful possession of a firearm, drug distribution or trafficking, driving under the influence, and or a misdemeanor for which a person was sentenced to serve 90 days or more in jail, and that excludes suspended sentences. Okay, and then priority three is where people who have committed other immigration violations. This is a category which is limited to individuals who have been issued a final order of removal on or after January 1st, 2014. Now, again, if you're not under any of those three categories, which that does include a lot, but if you're not, then you're not a priority, but you could still be deportable. Now, let's say you're under a priority. What are the exceptions to enforcement? And this is where my office generally comes in, is we prepare these packets which try to argue that you should fall under an exemption to the priority and thereby get prosecutorial discretion granted. Now, the priority one, the people, or the officers who can make the decision as to whether to grant what you're asking are ICE field office directors, CBP section or sector chiefs and CBP directors of field operations. The only way that you're going to get out of a priority one enforcement is to show compelling and exceptional factors which indicate that you are not a threat to national security, border security, or public safety, and should therefore not be an enforcement priority. Um, so there's a pretty high burden to meet there, but certainly it is not undoable, and it is possible with attached declarations, evidence, all kinds of other stuff to try to prove your point. Now, the priority two has more officers authorized to grant that or to make a decision. It's the same officers as in priority one, plus all USCIS district directors and USCIS service center directors. Now, what is the burden that needs to be proven here? Well, there are factors indicating that you are not a threat to national security, border security, or public safety, and should not, therefore, be an enforcement priority. As you can see, the language of what is required is much less of a burden than priority one. Priority one, you have to show compelling and exceptional factors for the requirements, and priority two, you just show there are factors indicating. So even not being a lawyer, you will be able to note that it is a much lower burden to try to get out of a priority two enforcement. Now, priority three is even lower, and any immigration officer has the authority in which to issue a decision on a priority three enforcement prosecutorial discretion request. And what is necessary here is that the applicant does not pose a threat to the integrity of the immigration system, or that there are factors suggesting that the individual should not be an enforcement priority. So given that, there's all kinds of ways of trying to prove these items. Obviously, if you can argue you are not priority one but priority two, or vice versa, if you are not priority two but priority three, the lower the priority you go, the easier it is to get an exemption. So you would want to try to show that, in fact, either you don't fall under any priority at all, or you fall under the lowest priority that you can argue. Either way, if it's done properly, there's a decent chance it will go through. It is quite a bit more open than it used to be, and it's just a matter of properly arguing. So if you enjoyed the video, click like, subscribe, and there'll be more videos in the near future. Thank you.